Yes, so you were right before the break, right before the lunch break, and then you have a final presentation on legal matters. Let me tell you, I'm going to make it, I hope, energizing and revigorating for you. So here we are, and I'm going to start with two landmark cases, and of course. And the two landmark cases, I think, are going to help you in your research. One is the recent case by the European Court of Justice about the anonymization of data. It used to be the case held by the European Data Protection Board that the data were personal data if you could relate them back to the identified or the identifiable individual. As you can imagine, that would then apply to literally all your research. Whereas I always defended that, well, but if the recipient of the data, the organization to whom you sent your data to, if that organization cannot identify the person behind it, how then could we still refer to those as personal data? The European Court of Justice has confirmed this point of view. It was not only my point of view, but a point of view of many others as well. I think for you, as researchers, I would say this is good news, because then you are able to already do the anonymization process right here, send the data, and of course, all technical and organizational measures will have to be taken, but then you can send your data to the other organization with which you cooperate. And then for that organization, the data are no longer identifiable. And that, I think it's good news for you as well. Then you have already overcome a lot of legal hurdles if, of course, the data can no longer be regarded as personal data. That is, I would say, one landmark case. Yeah? Are you now awake? Are you all set and ready to go for some more legal matters? And in my presentation today, I'm so thankful for my colleagues who gave the previous presentations and for your questions, because I hope I can include some of your questions and also share my answers with you right now. The second case is about the data sharing with the United States. We all know, I mean, of course, we cannot hide it, but we all know about the situation as at present in the US. And I hear from many researchers that they have a fear about data sharing. Is it still allowed? How should we do it? Well, hand in hand with the previous case about the anonymization, there is a second verdict from the European Court of Justice that states that the current privacy framework between the EU and the US has been upheld. That means that with the previous situations, a little more in the past, where the data sharing was actually stated to be not right, now the court has upheld that, yes, we can continue the data sharing with the US under the current privacy framework. Okay, so of course, once again, we need to consider all the measures and we need to take care of the contracts that are right and whatnot, but still it has not been stated that no data are allowed to be shared any longer between the European Economic Community, a bit larger than the EU, and the US. And I don't know about you, but at the Netherlands Cancer Institute, we closely cooperate with many institutes in the US So it is important that the data be shared, no matter, of course, what the current situation is. Why? Because the data are going to save lives. Okay? Those are the two landmark cases that I wanted to share with you, and I hope it already answers one of your questions about anonymous data and the reference back to personal data. Yeah, all good for that. That was one takeaway I would like to share with you. Then, in the Netherlands, as you can imagine, we have a lot of developments with regard to the implementation of the European Health Data Space. We have it with regard to the Implementation Act that is prepared as we speak. And we also have it with the preparation of the Control over Human Biomaterials Act, de Wet Zeggenschap Lichaamsmateriaal. Allow me to take you through some of the highlights from the preparatory acts in this respect. And please also, if you have a burning question, for me it's perfectly fine if you ask it just in between. For me it's fine. I will run up the stairs and just have the mic together with you. Yeah? All right. The secondary use of data. In short, the European Health Data Space, the intention came from the necessity to share data. I mean, we have all been familiar, all too familiar with what occurred starting from 2020 with COVID. But even before that, of course, we have life-threatening diseases that need to be combated. And also, Europe wanted to have a specific act on European health data, whilst the GDPR, the General Data Protection Regulation, is a general act about sharing data and also protecting data. The European Health Data Space is more specific with regard to health data. It's about the primary use. I will not dig into that. It's about secondary use. And please note that secondary use in the European Health Data Space has been described more broadly than further processing in the GDPR. So what also falls within the hemisphere of the European Health Data Space is the use of data for policy making, for innovation, also for sharing data for AI purposes, and also, of course, for the secondary use of research. Yeah? So the European Health Data Space, in my view, is a promising act. What I truly do hope, is that with the European Health Data Space, we're not going to have the dichotomy that we saw with the Implementation Act of the GDPR. We saw, and we still see in Holland, that we have like two sides, where one side is stating, well, we need to have the patient's consent, the patient's contribution, we need to have the civilians involved, and I fully agree. And the other side says, yes, but we also need to share the data because data saves lives and we need to have the data for research. And I fully agree. So in my view, I do not deem that we should look at the data from the two sides. We should look at the data whilst protecting the patients, whilst protecting the data itself, but also whilst having a clear view at the necessity of data sharing. And of course, we should not be blind to all the obstacles and hurdles. But in my view, it's too limited to say that because of legal constraints or ethical constraints or technical constraints, nothing is possible. So much, in my view, is possible if we are willing and able to combine our views and to join our forces, rather than that we're going to say, this is the problem or this is a problem, because once again, there is the road in between. European Health Data Space has tried to overcome some of the previous hurdles. It has also stated that the GDPR, of course, still applies. So the two acts are operational next to each other. It's not the case that the European Health Data Space has replaced the GDPR. It's not that the GDPR still overrules the European Health Data Space. Please, if there's anything I would like you to take away from my keynote today, when you come home, that you have understood and perhaps you have embraced the view that the European Health Data Space and the GDPR are not penal laws, are not laws that say you cannot, you are not allowed that, you should not, you may not. No, there are two laws that give you angles, that give you highlights, that give you guidelines as to how we can share the data, whilst, of course, protecting the autonomy and also the patient's rights. Yeah, so once again, if you're going to have a nice dinner this evening, if you could remember this one sentence, I would be very happy about that. Now, then if we turn to how then is the European Health Data Space going to do this? What is envisioned in this space? There is a debate going on right now in Holland. Of course, European Health Data Space states that yes, we're going to have data holders and we're going to have the recipients of the data. And the data sharing then will need to take place via a so-called health data access body. In all the European countries, as we speak right now, a health data access body, or perhaps bodies, is or are going to be set up. In Holland, there is now a preparatory round of meetings as to, is it going to be an organization, one organization? Is it going to function similar to the Central Bureau for Statistics? Is it going to be a different organization or whatnot? Apart from that, or in addition to that, I should say, in addition to that, of course, you already share data. You already share data throughout the world, I hope, throughout Holland, I hope. Will those current routes, will those still apply? Or will we have to take that one route via the health data access bodies? Our legislator has not said anything about that yet, but rumor has it, and please, well, leave it as far as you can here, but rumor has it that we are still able to have the two routes, that you are still able to share your data via your current routes, whilst also in the future you could also have the data sharing via the health data access body. Once again, and I reiterate this, it is not a law yet in Holland, but I'm very curious how it works, and in the latest talks that I've seen, I saw more tendency towards the two routes that still apply. Okay, I think for you that could be of importance, since of course you already have so many data sharing between national healthcare institutions and on an international level as well. Second, with regards to the health data access bodies, that was one of the questions I think from you in the back. The data will have to be shared anonymously. So, and if anonymous data sharing is not possible, then at least in a pseudonymized way. So the concerns that I fully understand as to, oh my gosh, will the data then be public in the world, identifiable? No. The data will be shared either in a pseudonymized way or in an anonymized way. As regards the applicant, who then, which organization can apply for the data, then yes, both public and and private organizations can apply for the data sharing. But once again, we'll have to go through an entire procedure, and once again, the data for the recipient will not be identifiable to the individual natural person. I hope that perhaps could take away some of the concerns that you may have as regards with which organization do I need to or have to share my data. Yeah? Then the time frame, of course, is that by 2029, and it seems far away, but actually it's not, by 2029, this system should be working. What does Holland need to do? A lot. Holland needs to work on the Health Data Access Body, which it does. Holland needs to work on the Implementation Act of the European Health Data Space, which it does, although, of course, we are now in the situation in Holland where we're waiting for the upcoming elections. So, a lot is done at this moment, and also a lot is not done at this moment. So that's the legal side. And last but not least, all the aspects with regard to the actual data sharing are also discussed. So the technical measures, the platforms, the frameworks, it's all discussed. 2029. I do hope that we will be back here in 2029 and that we're going to say together, it works. It really works. Yeah. There. Now, I'm going to not dig into, but I'm going to roughly go over some legal changes perhaps necessary. One is in the Dutch Medical Treatment Contracts Act. As you know right now, or as you may know, in Holland, consent prevails. So the patient will have to give its consent for data sharing for secondary research purposes. And only you could go away, to say it that way, with a no objection if, of course, it is impossible to ask that explicit consent and if you have taken all precautionary measures. Now, in the European health data space, the system will flip-flop. So the principal rule will be that you as a patient or client, you consent unless you object. So the system will flip-flop in Holland as regards the Dutch Treatment Medical Contract Act. As regards the preparatory phase with regards to the Wet Zeggenschap Lichaamsmateriaal, so the Materials Act, the Dutch Council of State, de Raad van State, has provided an advice that this act will have to be in line with the European health data space. So that means that also a system of no objection then will apply. But it could be that as regards sensitive materials, there will be still the opt-in, so the explicit consent. And the European health data space provides for that option. So in summary, what will occur in the future? I do not know. What I do hope is that we all could and will bridge the gap between health data sharing and health data protection. In my view, it is not this or this. it is the balance that we need to find, the fair balance that we always need to find between, of course, the data sharing for the common good and also the protection of our patients' and clients' data. The fair balance then will assist us in also making sure that we have trust from our patients, that we as organizations are transparent about what we do, and that at all times that we are going to communicate, truly communicate in connecting with each other. Thank you so much. It was a pleasure, and I thought that you were still active, so thank you.
Irith Kist. What I was thinking about during your presentation is who here in the audience are currently doing research and sharing data nationally or internationally, with a raise of hands. And is there someone who wants to elaborate on when you see the presentation of Irith, does it help? Will it not help? Does it help your research in sharing this data nationally or internationally?
In what extent do you mean?
Well, I think maybe my question is, did it offer new insight or make you enthusiastic about, now I might be able to work together with colleagues from abroad more easy, or share in an easier way?
To be fair, no.
What's your concern?
More hurdles.
Okay.
It's nice that we were able to share data with international organizations, particularly in the US, but I'm still thinking about sharing of biosamples, sending them out, what data is in there, also the informed consent that we are obliged to do with the GCP rules, that it needs to have a specific rule on whether data will be shared further outside the EU or inside the EU, and you need to show to the Method Ethics Board that it serves the purpose of the research, that those data will be shared.
Lots of hurdles.
And obviously that will be a no if it's just going to be in a general database or shared for further research for the general good of the healthcare worldwide. Mm-hmm. So it sounds nice, but I'm looking at a lot of next hurdles that need also to be taken.
Yes, thank you so much. Yes, I do understand your questions. And also with regard to good clinical practice, of course, we always need to have the ethical issues taken care of as well. I do hope with my presentation that it's about the entire picture that we need to sketch. And with regards to the new European legislation, I think we do have opportunities rather than that we have the new. Yeah.
Yeah, but as a research coordinator, I try to explain how stuff needs to be executed for the researchers within the UMCG, and that both laws, that I should consider them as guidelines. I'm not sure that's going to help my researchers. And then you get the UMCG guidelines and alternative guidelines. So I need to see how that pans out to make the story to my researchers on how to execute research at the UMCG. That I can come up with a simple story that is explanatory on how to deal, and not only the if scenarios.
Yeah.
A simple story.
Simple story. I'm more than welcome to come to you. Yeah.
More questions? Thank you. Oh, wait, where? Oh, you're in the flank.
You meant someone else, though.
For me, it's perfectly fine. Feel more than welcome to ask your question. Yes.
Thank you so much. I just have a question regarding the beginning of your presentation, the verdict that you were talking about. Because as I understood, since you're sharing pseudonymized data, meaning there is an identifier or like a code, basically, that doesn't directly identify but allow identification of data, you're just sharing the pseudonymized data, but you're not sharing that code list.
Yeah. Yeah.
Maybe I'm stupid, but what is then even the practical difference between anonymized and pseudonymized data anymore? To me, that verdict seems like we now only have two categories of data. We either have anonymized data or we have identifiable data, just where identifiable data could have two different categories, directly including the identification or just being two files, one with a code and then the code list?
Very good question, and not stupid at all, as you say yourself. No, thank you so much. No, the thing that the court justified and explained is that it depends on the case, and you will need to have a distinction between the sender and the recipient of the data. So pseudonymized data still exists, of course. There's still the truly identifiable data, then you have the pseudonymized data, and then you have what you could do is not share that code with the recipient, and then for the recipient, the data are then anonymous. And that is different from what the European Data Protection Board held, namely that for the recipient, those data would also still be regarded as personal data. And the court has stated, no, that's no longer the case. And in that sense, you have more opportunities for data sharing. Yeah.
Yeah, sorry, I'm going there and then back to you. Oh.
And also there was the question as well.
Oh, over there, okay.
Yeah.
Hi. Yeah, maybe I would like to add a little bit my help clarify things. The personal data is not it's not an intrinsic characteristic of data. It's a relative concept.
Yeah.
So it very much depends on the context. And this is actually something that in the decision was explained, like data becomes non-personal in some context, so anonymous, but it can really become again personal in another context. So it is a changing situation because it's pseudonymous.
Exactly.
It becomes truly anonymous when it's not going to be personal regardless of conditions. So we do have a more reasonable approach, which means like if you share data with strings attached, and very likely strings attached like a promise, not going to be making identification efforts, then it becomes virtual anonymously, put it like that way, which means you have freedom to share data with other countries.
Thank you so much. I think we should write an article together on the interpretation of this verdict. So yes, thank you. I fully agree. Yes. And then we had a question right there.
Yeah, over there. And
there.
then
I think the lady right there, or was it already?
Where? Where is the question?
There was a...
It disappeared.
It disappeared. Or there.
Okay. Wait for it. I'm going to throw it to you.
Ooh.
Did I say anything wrong about my throwing skills?
Yeah, just for clarification, because your the elaboration makes sense, but we also heard in some previous talks about the combined linking data sets, right? So how can you be sure, like, okay, I send it to this person, and right now they don't know anything, but they also request access to other data, and then they link these data sets, and now you're not in that situation. So I guess what you're saying is that there would be some promises, like, I will not link this data with any other data set, and this would then, be the simple solution. Just to clarify if that's what was meant.
3 words, legally binding agreement.
Okay, yeah.
Legally binding agreements. Okay.
And also the context, once again, is very important if you're going to share the data with others once again.
Last question. You can throw it through the... Yeah. Are you okay? Fully awake for the lunch.
I'd like to refer back to the previous presentation where we saw that the legal binding stuff whatsoever is very nice, but if you send it to the US and a commercial company decides to do it elsewhere, you're done. So that's very nice to have a legal binding thing, but if they decide to use AI to figure out where the study has been executed, look on Facebook, trace people who go somewhere with the similar characteristics of a study, I can go forward. And it's not too difficult nowadays to use all sources to get that pseudonymized data and figure out what the actual individual is, if you want to. Governments. I mean,
very good point. Very good point. And we need to.
For my part, but you know,
Yeah.
we must also not be rather naive in these aspects. And I think the previous presentation with the example of, was it clear or whatever, shows what really happens in the world, despite our good intentions.
Yeah, great.
Last reaction?
Yeah.
For you, Irith?
I fully agree with what you say. And yes, we need to take care of all the technical measures and also, as the gentleman said right there, about the context. So yes, I fully agree. Yeah.
Can I have a last Warm round of applause for Irith Kist.